Good afternoon. I hope this video message finds you all in good health and spirit in these difficult and uncertain times. It is a great pleasure for me to take part in this 21st International Conference of Chief Justices of the World. So let me start my speech thanking the organizer for the invitation and for the impressive, as usual, organizations of this high-level international meeting. City Montessori School of Lucknow, an institution which won the prestigious UNESCO Prize for its activity for education and peace, has the real ability to gather justices from all over the world for mutual exchanges of ideas which are very fruitful. The topic of our thematic group is the judiciary and its role in building a more secure and equitable world. In my country, Italy, judges are committed by the Constitution to build a more secure and equitable society. This stems from the principle that judges are submitted only to the law, from the recognition of the fundamental rights of the human beings, and from the principle of equality and non-discrimination among them, and moreover from the engagement by the state to remove any obstacle to the effectiveness of this principle, with the aim to grant a fair treatment to everyone. As the leader of the medical organization Emergency, Mr. Gino Strada, said, "Human rights has to belong to everyone, but really everyone, otherwise you can call them privileges." In general, the power of judges has its legal basis and limits in national laws, being expression of the national legal system. At a first glance, judges are only expression of national powers and are able to act in a national sphere of competencies. The said national perspective is, however, really a narrow one, as it leans on the contrast between internal and external, identity and otherness, and it implies a conception of the other than us, of the foreigner, as someone excluded from the rights that citizenship guarantees. The said contrast is now going to be overcome by the events, and our presence here certainly witnesses it. We live in a globalized world where goods and services are exchanged all over the world, capitals are transferred by electronic means in few seconds, and people wish to move freely across borders and countries. Multinational companies, but also international criminal organizations, seem to rule the world, while inequalities among people and countries increase and the distribution of wealth is often unfair. The recent pandemic showed it clearly. In this framework, states must renegotiate part of their sovereignty within an increasingly extensive global network made up of interdependencies, influences, and external conditioning. This leads also judges to overcome the traditional jurisdiction's boundaries. The previously right and linear bulwarks of national identity becomes liquid and mobile. As commercial exchanges and social interaction became more frequent and intense, the international community started to face the new problems by judicial cooperation, especially in criminal field, and by mutual recognition of judgments in both civil, criminal, and commercial field. Terrorism, conflicts, economic crisis, health problems, poverty and hunger, the well-being of children, the inequality distribution of wealth, and many others are very serious problems which have in common they can't be faced only at the national level, as they involve the need of an international cooperation among the different national authorities and, moreover, a dialogue between judges. To face these new challenges, national rules are often insufficient, and judges need a common approach, both legal and practical, to solve their cases. In the Italian Constitution, there are some rules which make the national legal system open to external rules. A first instrument for that is making judges respect the obligation arising from the international community, from customary rules, as well as from international treaties once ratified. Article 117 of the Italian Constitution set the clear principle that the legislative activity is performed under respect of the Constitution, of the European Community constraints, and the international obligations. Italy allows, therefore, in conditions of parity with other states, to the limitations of sovereignty necessary for an order that ensure peace and justice among nations. It promotes and favors international organizations aimed at this purpose. It is useful to recall that, following this principle, Italian judges apply the United Nations Conventions, and I recall here in particular the United Nations Convention on the Rights of the Child, that one on environmental modification, and that on the law of the sea, the Convention on Contracts for the International Sales of Goods, those against torture, corruption, drug traffic, and moreover, the Convention against Transnational Organized Crime. The Italian state, including its judges, are bound by the judgments of the European Court of Human Rights, an international court set up in the framework of the Council of Europe, an organization which gathers 47 European countries. This court gives protection to human rights of 1 out of 7 people of the world population who can lodge with the court individual application without intermediaries. The proceeding before ECHR may lead to the condemnation of the contracting state for violation of the Convention on Human Rights. Among many judgments, it is sufficient to recall here those related to the prohibition of torture of people suspected or indicted of being terrorists, where ECHR stated that some fundamental rights, so-called absolute rights, can be derogated in no cases, while other rights are susceptible of limitation under the Convention, but the interference by the state must be prescribed by a clear law for a legitimate aim and must be proportionate. In other terms, the court said that the obligation to protect fundamental rights is stronger than the obligation that may arise from a national rule, so that the principle affirmed at the international stage must prevail on the domestic law. A more powerful instrument is provided for the application of the rules issued by the European Union, an organization composed after Brexit by 27 states. In this field, the European rules and judgments are immediately applicable in national judicial proceedings, and they prevail on national rules. For instance, national judges can set aside a national rule conflicting with the European rules stating the principle of freedom of movement of people, goods, services. It happened, however, that the international community too is sometimes unable to grant protection to fundamental rights. I recall on this topic a case. Some years ago, in Italy and in Greece, some victims of war crimes such as deprivation of liberty, forced labor, mass murder, committed by the Third Reich, the German state before and during the Second World War, lodged complaints with the national courts, claiming for damages. As the German state was condemned to pay damages by Italian and Greek courts, Germany complained before the International Court of Justice, invoking the principle of immunity of the state while exerting sovereign powers. The situation became paradoxical since the subject of the dispute before ICJ were no longer the Nazi crimes, but judges and their powers. By its judgment, the International Court of Justice established the duty of Italian courts to deny their jurisdiction owing to the immunity of the German state. After the judgment, the Italian parliament passed a law which excluded the jurisdiction of Italian courts for war crimes committed during the Second World War, but this law was challenged before the Italian Constitutional Court, which declared it unlawful with regard to our Constitution and made it void, saying that the principle of immunity is not an absolute one and can be limited insofar the acts complained of are crimes against humanity, being so irrelevant in case of gross violations. I recall this case as it shows how the protection of fundamental rights must be assured also when the international community is not able to grant it, and then the task is committed to the judges. I started with the concept of jurisdiction as expression of the national legal system. I continued through the need of a wider perspective which entrusts the international community to protect people, and I eventually went back to national judges, called this time to apply principles protecting fundamental rights. I stop here, leaving the floor to other colleagues, and I really thank you for your attention.